Alrighty, so this is Diesel We the People News. Okay. Um, this is going to be a three-part series due to the direction what has been going on in Texas. There's going to be two parts of this video and one part of another one so you can get the basic idea of what they are doing upon us. Okay. Due to lack of our knowledge. Okay, I'm not giving legal advice. I'm not an attorney, not any of that. This is educational purposes only. Okay. Uh, so any claims on here on this video is just from the other party, but I digress. Alrighty. So here's kind of a little bit of the deal here. Uh, this is capital S, capital N, capital A, capital F, capital U, radio. Okay, and it's titled Randy Kelton suing all judges in Texas. Okay, and good for him. Needs to be done. So, due to YouTube, when you download these things, it kind of goes reverse effect. So this is going to be considered part 3, the way it downloads. All right, so I got to do everything backwards to do 1, 2, 3. All right, so this is going to be the end of the 3-part series that I'm recording on my behalf. All right, let's talking too much. Let's go back. Doop, doop.
So to get her out of the car and get the paramedics there and get her stabilized, and the policeman asked her if she wanted to file criminal charges against the security officer that grabbed her, and she said yes. The policeman immediately went inside and solicited criminal complaints from the security officer because they didn't want to have to explain why they tackled her and hotboxed her when she was the victim. So they went in, and we have it on video cam on their dash, their body cams on. The policeman pressured this woman to write a criminal complaint. So they write a criminal complaint against her. It's Class C misdemeanor. And they give her a ticket. She goes home. She wouldn't take a deal. And she, I was helping her. And finally, after 2 years, they dismissed the case for, look for it, lack of evidence. She demanded an examining trial early on. They didn't hold one. Then 2 years later, they dismissed it for lack of evidence. Well, good luck, guys. So, this is what I'm claiming. First, under 1406, 1517, they're required to take a person directly to the nearest magistrate, but they don't. They take them to jail. And then they're supposed to hold an examining trial, but they don't. They hold what they call this magistration thing, that thing they implied from the subordinate clause added to 1406 and 1517. Problem: there is no provision for a magistrate to set bail in Texas except in Chapter 16. And Chapter 16 is the one that you use for an examining trial. But the lawyers interpreted 1406 and 1517, 1516, the changes to it in a way that rendered Chapter 16 void. And under the Code Construction Act, Government Code 3.11, Government Code 311, statutes must be interpreted in paramateria with the corpus juris. They must be interpreted so that they do not contrast with existing law. These lawyers interpreted 1406 and 1516 in a way that eliminated Chapter 16, and that made the interpretation unconstitutional. That's my claim. but it causes another problem. A magistrate has jurisdiction based on a criminal affidavit, but the magistrate only has jurisdiction for the purpose of holding an examining trial and making a determination of probable cause and setting bail. Once he has made a determination of probable cause, if he finds probable cause, or even if he doesn't, he is to issue an order under 16.17, and he is to forward that order to the clerk of the court of jurisdiction. The statute says if an order is not forwarded to the clerk within 48 hours, the accused shall be discharged. Now, what part of that is hard to understand? It is the finding of probable cause by a magistrate and the filing of that probable cause finding with the clerk of the court that transfers jurisdiction from the magistrate to the trial court. Without it, the trial court doesn't have jurisdiction. Now, if any of you have ever been arrested in Texas, I defy you to find a 1617 order in your case. There won't be one unless you're in Austin, and if you're in Austin, there will be one, but it's fraudulent. It was filed by a magistrate who held a magistration. Now, if you type magistration into Microsoft Word puts a little red line under it. It doesn't recognize it. I don't either. It does not exist anywhere in Texas law. They made it up. Yeah, they did. And judges have actually ruled based on magistration. It's all made up. There's no legal ground for it.
I know. I've heard him say it many times.
Yeah. So they've been doing this for 40 years.
Right.
So the question is, in all this time, how is it that every single court in the state of Texas does it horrendously wrong, but they all do it the same way? How does that work? How do 54 different county sheriffs wind up following the same procedures? And I don't know how many JPs, at least 4 or 5 in every county. And we've got 250 counties. And all the district judges, county judges, appellate court judges, all the judges do things the same way. How does that work? How does that happen? And for me, for a long time, that was an issue. And then they made a mistake. The legislature added something to Chapter 17. Chapter 17 is the section on bail. 17.024 says that the Texas Court of Criminal Appeals, in conjunction with the Office of Court Administration, shall develop curriculum to instruct magistrates in their procedures for setting bail and other duties. I read that and said, holy crap. That's how it got universal. Texas Court of Criminal Appeals created the training that trained them to do it wrong, and then they gave it to Texas State University, and Texas State University, one of our illustrious Texas law schools, taught everybody to do it wrong. My son-in-law is a JP. I went through the code with him before he got elected. He looked at it and he said that all makes sense. And then he went to training and trained to do it totally different. And so tell me, what do you think he did? Scott, you think he did it by the code or did it by the training?
Of course, he did it by the training. But this 17 point, this new edition though, didn't you say that this is like a brand new, just done, added to the?
No. 1965 is when it first appeared.
Okay.
And then in 1970 they had a case, Troy v. State, where the state said you only have a right to an examining trial in a felony. Well, that's not right. That's not true. And it goes to a perception, an improper perception. You hear people all the time talking about their rights. And we've been conned into doing that. Those things you call your rights, they're not your rights. The Constitution grants you nothing. The Constitution does not speak to you at all. The Texas Constitution speaks to public officials and forbids them to do certain things and commands them to do other things. I don't have a right to an examining trial. I also don't have a right to be arrested. I don't have a right to be drug off to jail. I don't have a right to be drugged before a court to answer. That goes to a concept we call due process. Public officials are commanded by law to do these things. They also are commanded by law to provide me with an examining trial. And the providing of an examining trial goes to the due course of the laws. And Article, which one is it, 5 or 6? Oh, I'm sorry, I'm thinking of Fed. In Texas, Article 1, Section 10 guarantees me the due course of the laws in the state of Texas area. It commands public officials to provide me with the due course of the laws of the state of Texas. So that's something I do have, technically have a right to. But they have decided they didn't have to bother with all of that. And because of that, prosecutors being directed to give legal advice to the police and magistrates have advised the police and magistrates in practices and procedures that are administratively convenient and adjudicatively expedient. And they have created the worst police state the world has ever seen. Prosecutors have advised the police and lower courts in practices that make it such that prosecutors do not have to prosecute. And they created a situation where defense counsel cannot defend. It doesn't have to. Defense counsel will take your retainer and do nothing. He doesn't dare do anything. If he tries to adjudicate your case, the judge is going to land on him like a ton of bricks and likely to screw his next client to get back at him. And I had a lawyer tell me, I can't do that. It would be unscrupulous of me to get the judge into a position so he'll screw my next client to get back at me for helping his client. So what's a lawyer supposed to do? And the prosecutors, they don't care if you're guilty or innocent. They're going to get a deal out of you. And they do. In 2019, the last year I have good numbers for, the counties in Texas spent $990 million for pretrial incarceration. 60% of the jail population is pretrial. People who've not been convicted, but who the prosecutors are holding until they force them to take a deal. And at $50.79 a day, the Office of Court Administration reported $990 million in pretrial incarceration and another $254 million for court-appointed counsel. But I ran the numbers. In a state of 29 million people, and I forget the percentage of the people that were incarcerated, I think it was 8%. 8% of 29 million times $50 a day times 365 comes up to $5.4 billion. Almost double the entire budget. But see, that comes out of the county funds. So it's not reported in the general funds. I think the Office of Court Administration lied to us. But I'll find that out in the process of this case. We're taking on everybody. And what was working on this morning is an issue that I come across on occasion. If those of you are listening, if you deal in the Patriot area much, you've probably heard the term rights belong to the belligerent litigant. Oh, no, they don't. Johnson v. State cites that quotation from two other cases. I looked in those cases. It's not in there. It's BS. This morning, I'm looking for a solution to my claim that every judge in the state of Texas has acted in criminal violation of state law in every single prosecution they have prosecuted. That creates a problem where every judge in Texas is disqualified. And there's this maxim of law that I've heard about, and I've actually repeated it. If all are disqualified, none are disqualified. And that came out of a couple of cases in the Fed. One of them was Phila v. American Bar Association. The other one is Brinkley v. Hasek. They both cite Turner v. American Bar Association as the source. It says there is a maximum of law to the effect that where all are disqualified, none are disqualified. Evans v. Gore. Well, I looked up Evans v. Gore. It's not anything about that in there. It's a case about income tax.
So they made it up.
They made it up. Don't exist.
Holy shit.
And then in Texas itself, I found
By the way, people, attorneys actually do that. They throw cases in there, and if you don't, especially if you're representing yourself, wink, 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 they'll just slap cases in there. So when you do these things, you literally have to actually look up the case and read it. Because they just slap it in there, and hopefully you don't read it, and everything's good. The judge is not going to read it.
nothing. As far as I can tell, it has not been touched. So the state's in a quandary. I am alleging criminal conspiracy, street gang 7201. I'm accusing the Texas judiciary of being a street gang.
Mm-hmm.
And the street gang has a recognizable hierarchy, and they commit multiple predicate acts in furtherance of an ongoing criminal conspiracy. And Texas has been sued for that before, so it has precedent. So I'm suing all the judges, and their issue is I'm not making a general assertion that disqualifies all the judges. I'm saying you pick me any judge, I will go to his docket and I will pull you criminal charge after criminal charge after criminal charge. Any judge that has presided over a criminal trial or when acting as an attorney has represented a criminal client has acted in direct violation of state law and is subject to disqualification. These are specific grounds for disqualification. So every judge is specifically disqualified. So I requested a court of inquiry. What's that under? 51, I think. Chapter 51, Texas Code of Criminal Procedure provides for a court of inquiry. And it requires the judge who receives the request for court of inquiry to ask another judge to convene a court of inquiry. Well, the problem is every judge is disqualified. So I'm asking them to appoint an associate judge under, I forgot to write the statute down. It's in the government code. I'll have to look it back up. But there's a specific code authorizing them to appoint a associate judge, and the associate judge requirements only are that they are an attorney and have practiced in Texas for 4 years. So I want them to appoint a law school professor who has never sat in a criminal case and who has never represented a criminal client. And there are a lot of lawyers out there that don't touch criminal. Appoint that guy to sit in the court of inquiry, and a similar guy to sit in my case. So Tara and I are both in the case because we were both negatively affected by the governor's mask mandates and by due process. I have sued my county, the county I live in, for $400 billion for using this process on me. So I'm considering consolidating my case with their case, with this case, put them all together and sue everybody at once. That's my story. Everything in Texas law is horrendously illegal, and it appears as though it was consciously and deliberately put in place by the Texas Court of Criminal Appeals in conjunction with the Court of the Office of Court Administration, in conjunction with Texas State University. And that's good because Texas State University.
Alrighty. So, there we go, people. Just with People News. Check it out. Till next time.